Chairman, I rise on behalf of the Green Party to oppose Part 2, and for many of the reasons that have been outlined by my Labour colleagues. And I think the UN Convention on the Rights of the Child is very relevant here, because the essence of that is that the rights and the welfare of children come first. And if you apply that to this situation, 12 or 13-year-olds certainly imposing this regime of DNA samples, bodily samples, is not putting the rights of children first. And look at this in perspective. It wasn't long ago that we didn't have any of this DNA testing, which, when the Select Committee discussed the bill that this Part 2 is amending, it was said quite clearly by a number of jurisdictions that, and the Privacy Commissioner as well, that this is particularly intrusive. Taking bodily samples of people and their DNA is particularly intrusive, much more so than fingerprinting or other forms of biometric testing, and it is intrusion on the privacy of the person. And then if you look at it in the context of this has just come in, it's very intrusive, we haven't had it for too long, why do we need now, and the Green Party opposed this original bill about bodily samples, bringing in effectively compulsory bodily sample extraction, why do we have to now bring it right down to children, 12 and 13-year-olds? There's no argument why it has to be brought to that level. And the bit in the bill here, it talks about the suspect, and it should be borne in mind that you don't actually need to be charged to have your bodily sample taken. According to the original bill this is amending, you can just be a suspect. You don't even need, and it's a couple of months that the police have got before they charge, after they've actually taken the bodily sample. Then there's the question, it says here, about the 12 or 13-year-old consenting. Now, when you're talking about 12 or 13-year-olds, are you really talking about consent? Some 12-year-old bundled into the back of a police car, taken off to the station and asked if they will consent. Now, in any rational analysis, there's no consent there. 99% of that is you are going to do what the police says, and there might be a few implications that if you don't, there might be a few downsides for you and your family, etc., etc.
Order. The member's bringing the chair.
I'm sorry, Mr. Chairman. I'm talking about you in the generic sense, and I shouldn't use the word. I think that's the problem, I think, with a lot of legislation in this House, that we keep running down the track of more and more restrictions on people's rights. And sure, you can argue an upside to it, that there might be a really bad 12-year-old and this particular provision will enable a bodily sample to be given, and that person may some point in the future be convicted, and that will be good. But if you put it in the balance of what's happening in the society to children, criminalising children, then adding the extraction of bodily samples from them in essentially a forced way, which is the greater problem for society. The occasional child who might get off when they should be convicted, 1 in 1,000 or whatever, or the intrusion that this is going to cause and the infringement on children's rights, contrary to all our commitments to the International Convention on the Rights of Children. Thank you.